Good morning, everyone. My name is Christine Salgado, and I'm a Managing Principal within the Marsh Pacific Cyber team. I would like to warmly welcome you to the second part of our Cyber Risk Masterclass series, addressing the governance challenge around cybersecurity. Cyber risk is always evolving. Motivations for cyber attacks are wide-ranging, and threat actors are incredibly varied, making planning defense of cyber risk very difficult. A major cyber event that has the potential to cause significant reputational, financial, and operational disruption can easily come from an unanticipated direction. Existing risk governance models that have been used to manage physical and financial risks may no longer be effective in addressing and managing cyber risk. We have broken today's session up into 4 topics: board responsibility and governance, the class action environment, the role of government, and the insurance market cyber solution. And this morning, it is my absolute pleasure to introduce our incredible panel of experts who will explore how companies can effectively address the governance challenge around cybersecurity and resilience. So I'd like to introduce Craig Claughton, who is a Managing Director and Head of Marsh's Financial and Professional Services Division within the Pacific. Craig has long-standing experience both as an underwriter and a broker, representing Australia's largest public companies and banks in the provision of risk management services. He also leads some of Marsh's most complex insurance placements. Lisa Fitzgerald is a partner at Lander & Rogers, specialising in technology, media, telecommunications, data, and privacy. Her progressive experience in this space has seen her assist clients on a wide range of commercial transactions and advisory matters, including data governance, corporate governance, as well as advising the state government. And our final panel member for today is Alistair McGibbon, who is the Chief Strategy Officer at cybersecurity firm CyberCX. Until recently, Alistair was the former head of the Australian Cybersecurity Centre and was selected by former Prime Minister Malcolm Turnbull as a special advisor on cybersecurity. Alistair has incredible experience in the cybersecurity and advisory arena across both the private and government sectors. Thank you to all our panel members today for participating in what I have no doubt is going to be an incredibly insightful and thought-provoking session. There will be time for some questions at the end, so I encourage the audience to please utilise the chat function to send in any questions that you have for our panel. So the first topic I wanted to dive into is board responsibility and governance. As the threats emanating from cybersecurity risk grows, a significant challenge is facing company boards who are under increasing pressure to be held accountable for failures to protect information assets and business operations from cyber security failures. So the first question I wanted to pose to the panel is a broad but important one around cyber risk literacy and education. This particular question is posed with reference to the Centro class action decision, where directors were held responsible for failing to pick up accounting errors in financial statements. So what level of responsibility should board have in addressing cybersecurity and resilience? Do directors have to be IT or cybersecurity savvy, or is reliance on experts acceptable? Lisa, if I could start with you.
Thank you very much, and good morning, everyone. It's a pleasure to be with you talking about this increasingly important topic. The Centro case is a federal court case, and it's about the responsibility and accountability of directors, which is relevant to cybersecurity and information security generally for lots of reasons. But perhaps if we start by recalling the core directors' duties under the Corporations Act, which are duties to perform functions and exercise powers with good faith in the best interests of the company, with care and diligence, and not to improperly use your position or information to gain personal advantage. So these statutory duties are a combination of common law and equitable fiduciary duties, and they really all spin out of that core care and skill duty. And so that does require more than simply reading and reviewing financial statements, and it certainly involves a little bit more than outsourcing wholesale the function to experts within your team. Now, not all directors are equally skilled and experienced, and infinite knowledge is, of course, impossible. So what is generally permitted to compensate for that lack of expertise when it comes to technical IT issues, artificial intelligence, algorithms, data sets, data hygiene, it's almost a foreign language. So what is acceptable? And it is definitely acceptable and probably mandatory to get the expert advice that you need, to rely on, your employees with those skills, to bring in legal counsel and a team of people that can help advise you, but that will not transfer the liability that directors have for that particular function. I just want to make the point though in relation to AI and the sort of adoption of new emerging technologies with sort of bravado and increasing appetite. I was talking to one of the world's leading AI experts the other day, and he said to really understand AI, you have to have a PhD, and there's only 10,000 people in the world with that qualification. And so I think that, again, just points to the real need to make sure that you're properly advised, but also to know that this is not something that you can do without exercising your own common sense, really, in relation to the information that you've been given. If I could just mention as well, the duty is about exercising a balancing act between the reasonable foreseeability of harm of something and the potential benefit to the business. So there's a weighing up exercise that needs to be done. It's not about eliminating all risk. It's about weighing it up. And again, just using the information that you have from your advisors will be key to that. Cyber attacks are clearly on everyone's radar when we're living in an era where every company is a tech company. I'm sure you've heard that before. Whether you're a technology vendor or a technology purchaser, every company is using technology. And when you're using technology, obviously there is the risk of a cyber attack and a data breach. And so that's a reasonably foreseeable risk, and it's something that should absolutely be on every board's radar and every director's core responsibility.
And Alistair, you've had roles that sit in both private and government sectors. What does the government feel is an appropriate level of responsibility for directors with regards to cybersecurity? And in your opinion, do you think that's reasonable?
Thanks, Christine. And if I can just build on what Lisa was saying, I'll start by saying cybersecurity is the wrong phrase for us to be using. As we know, it should really be something like cyber risk resilience, because when we use cyber security as a phrase, security implies that it's a binary thing, I'm secure or insecure. As Lisa said, this is actually a risk question. And it's not just a question of risk to begin to answer your question of what the board thinks an acceptable level of risk is. As Lisa said, and as you've got here in the example, courts will determine from time to time whether or not that risk appetite was accurate. I would say, or acceptable, I would say that the government in Australia is increasingly moving towards adding to those responsibilities for directors and officers. So if you go to paragraph 36 of the 2020 cybersecurity strategy, the second dot point down makes an oblique reference essentially to increasing the responsibilities for directors and officers, more than likely through the Corporations Act. If we look at APRA's CPS 234 and the obligations placed upon boards to better understand risk as it pertains to the operations of the institution, and for the directors to be satisfied that they have the controls in place and the ability to respond to that risk when it is inevitably realised, and that's an important point. It is inevitable, and to Lisa's point, the consequences of that failure, the inevitable failure, will only increase as we connect technology. So from a government point of view, we will see increasing expectations set by government, legislative and regulatory. The critical infrastructure discussion paper, the draft legislation that talks about systems of national significance, all of those things are building towards increased responsibilities for directors and officers. Now, my, I guess, fear or one of my concerns will be that we move into too much of a compliance-based regime as opposed to a proper risk regime. And we know compliance forms a really, and a controls environment forms a really important part of this cyber risk resilience, but it's not the only part. So there are some things that directors and officers, and I'll be quick, I promise I won't hijack this whole thing. I know we've only got 4 hours, so that's good. I promise I'll be quick. But you know, boards need to satisfy themselves of that we know what the roles and responsibilities are inside organisations. They need to understand the policy framework that's inside an organisation. They need to know that there is a testing regime for controls. They need to be satisfied of the sort of what the capabilities are of the organisation. They need to understand what level of external testing and auditing is done, and they need to understand what's happened when risk gets realised and how responses are done. There are a whole range of questions. So to go back to the first question you asked, Lisa, I don't think people need to be experts. And I've spoken to boards in my various roles going way back to the very early 2000s. And often I'll have boards or C-suite folks saying, look, I just don't understand the technology. I don't understand how cyber criminals or nation states operate. But then their background might be in accounting, but they're able to make decisions on marketing and brand. They might be from a sales role, but they understand issues of P&Ls, right? So we all need to learn and start at least understanding the basic terminology of cybersecurity, which puts boards and senior leaders of organisations in a better place to be able to respond to what I think will be an increasing obligation from government. I'll end there just in the interest of time.
No, thank you. And yeah, that's a very important differentiation between cyber security and that being binary versus cyber risk resilience, which is a much more holistic approach to the overall problem that's facing boards. So Craig, if I could pass to you, you've spoken to many boards and spent time with their directors. Could I get your thoughts on the responsibility and accountability of directors when it comes to this area of cyber risk?
Yeah, and look, it certainly is a difficult one for directors. Directors today need to and probably do understand that the historical concept of being a director, where you were there to provide strategy and high-level guidance, is an historical concept. Certainly the Centro case proves that, and the laws in this area for responsibilities given to directors are becoming more and more onerous. So if you're going to be a director, you need to accept that you're not going to be an expert at everything, but you can't sit back and say, all right, well, I had the accountant come in, or I had the chief information officer come in and talk about cybersecurity, so I'm all good, right? That test is no longer enough. You need to be able to have demonstrated that you've done more than just sit at a high level, right? It unfortunately means that a director is effectively needing to get involved in the management of the business. Now, clearly the people that are managing the business don't want the directors coming and sitting at their desk every day, right? And I think that there is an interim period there. I think that there is a midpoint, if you like. But directors need to understand that they can't just say, all right, well, I've had one person come in, I've ticked that box, and away I go, right? And importantly, asking the right probing questions is really, really important from a risk management perspective. And then, of course, documenting what the process is, so that should you need to defend yourself in the future, you can say, hand on heart, these are the steps that I took, and we believe that they were reasonable. But it is a minefield.
It definitely is. Thank you. And I think, you know, it's certainly such a complex area of board responsibility, and it's certainly not made any easier by the next topic that we're going to dive into, which is around the class action environment. So as you would all be more than familiar with, the securities class action environment and the resulting claims that it brings has really contributed to quite a significant hardening of segments of the financial lines insurance sector. So I'm asking you to kind of gaze into your crystal balls here into what is a really relevant matter for directors and officers. Are you able to share your thoughts on whether you think class actions will stem from cyber incidents, and particularly data breaches, which we've seen a couple of those happen in the US? And if so, do you think they'll grow to a similar level to what we're currently seeing having an impact on particularly the D&O insurance sector? So Craig, if I could start with you.
My immediate response is yes, I do think this is likely. Sadly, certainly cyber insurance is likely to be the first port of call managing a particular incident. But when we look at directors' responsibility from a governance perspective, I think they will definitely be in the firing line. And we've seen this from other parts of the world. In principle, some of the key areas rather that I think that they will be involved with, people will look at how they handled the cyber incident, whether they acted quickly enough or appropriately enough. Did they bring in the right resources? Did they have the right risk management framework in place? All that is subsequent to the initial cyber incident. And then the second element that I think will be key is around continuous disclosure. The regimes here in Australia are very significant and somewhat different to other first world countries. And it's not beyond the realms of possibility that plaintiff attorneys armed by litigation funders may make allegations that they have breached their continuous disclosure regimes if they can establish that they had some knowledge about an incident and then did not disclose that to the market.
And Lisa, you're greatly involved in data and privacy advisory. Have there been any sort of rumblings or worry amongst your clients about possible data breach class actions being brought against them? You know, it's a bit of a broad question, but it'd be really great to hear your thoughts on that point.
Yeah, thank you. Data breach class actions are in their infancy, but there is absolutely a growing awareness of their potential to just take hold. There's currently a potential class action being prepared against Optus in relation to its massive data breach of 50,000 of its customers' data, which were published in the white pages. However, I think the threat of the class action really is one of cost and time and resources in terms of, you know, defending and settling any potential class action in the future. And that is a cost that's potentially worse than the actual regulatory fine that you might get as a result of a data breach. Excuse me. And there's also, you know, obviously reputational damage as well. And we've seen recently in respect of Toll, which has been in the news lately. Now, not a class action yet, but certainly, you know, a demonstration of perhaps not taking adequate measures in relation to its IT security and systems, such that 2 data breaches in 1 year occurred. And I think that, you know, the cost in terms of company value is seen in that example. The costs in terms of personal and professional careers of the people involved is also a cost, and then replacing those people in those roles as well. So absolutely, I think the class action is one of a number of threats, but there's also just general, I don't think companies can be building a fortress against every hypothetical risk, but I think this is definitely one that is more than hypothetical at this point in time.
Thank you. And before we moved on to the next topic, Alistair, was there any sort of thoughts you wanted to add to what Craig and Lisa have mentioned around the risk of class actions and cyber, sort of stemming from cyber incidents?
I think they're more likely to occur, of course. We will follow the steps of other countries. While I'm not necessarily inclined to like litigation for these things, it actually performs a useful role in terms of raising awareness and pushing cost into areas where we will then see the market respond. So I actually see a legitimate role for that type of activity, so long as it remains at a sort of a reasonable level. And that's probably the billion-dollar question. Can I just also say that while we talk about data breaches, I think we forget where the shift of criminality and nation state activity is in fact going. So we know that cybersecurity or cyber risk resilience is about confidentiality of data and systems, integrity of data and systems, and availability of data and systems. And the shift we've seen in the last couple of years has been towards attacking the integrity and availability of systems, which is much more significant in terms of harm. And I think that will then drive to much more sort of legal action by aggrieved parties. So I think that's one of the things that will cause it. And you know, I often publicly say, and I probably don't endear myself to people that much, that we've probably focused on the confidentiality bit fairly heavily for the last 15 to 20 years, and you'd probably give us a C- for that as a society. We've done very little to worry about the integrity and availability of that data, those data and systems, and that's where the real existential threat lies to us as a society, and that's where we'll see true harm come, and through that true harm we'll see the legal actions bubbling up, which I actually, as I said at the start, think has some probable net benefit for the community. The trouble is, most of our legislative and regulatory environment focuses on the confidentiality aspect, which I think is like putting a gate in a field and expecting that to have an effect on your cattle. You've got to build all the things around it, like a fence. And our legislative and regulatory environment focuses just on that confidentiality bit rather than the rest.
Yeah, absolutely. And at Marsh, you know, we've really seen this year that shift towards ransomware and I guess the tough decisions that directors have to make around whether they will pay a ransom demand or if they're going to go through sort of that long process of rebuilding systems and what flow on effect that'll have to the company's operations. And I know that this is a little bit off topic, but I don't know if anyone wanted to add anything around sort of, you know, the difficulty of making those kinds of decisions as a director. You know, if you pay the ransom, does it then have a flow on effect to your balance sheet and then potentially lead to a class action because of that?
I'm happy to...
Christine, sorry, great.
Go ahead, Lisa.
Oh, look, I was just going to say, absolutely, I think that's a critical issue. Insurance is so important to that scenario, but also is the decision as to whether or not to pay the ransom. And I think historically there's been a very commercial approach to paying the ransom and just getting the issue dealt with. I think now with sort of the rise of cryptocurrency and, you know, those types of payment requests, there needs to be a lot more thought given to whether or not that ransom is paid and the consequences for the business as a result of doing that. It can invite criminal liability in itself. So again, making these decisions properly advised is key.
Yeah, and Lisa, to take that a little a step further in terms of the insurance response to that, certainly good cyber policies do provide protection for the payment of ransoms. But you know, something goes through my head is how do we deal with a criminal and make a straightforward payment? Is that not like negotiating with a terrorist? You can never have a positive outcome to that. But a couple of important things to bear in mind, and the OECD a few weeks ago gave really good guidance in this respect, which was to say, right, before you make a ransom payment, make sure that you know where that money is going. Now, how the heck do you do that when you're dealing with a criminal? And be mindful, importantly, about whether that ransom payment might breach any form of sanction anywhere in the world. But that's again a complex network. But before you just pony up and write a check for your ransomware, for your ransom payment, be mindful of that. Or as a director, you may end up in a whole lot of other unexpected implications for you, some of which Lisa mentioned, which could be criminal, not the least of which is potentially breaching a sanction and then shutting your company down because your licenses have been taken away. It is a very complex field, and it's much needs to be considered very carefully before any payments have been made. despite the fact that an insurance policy is likely to provide cover for that. And remember, the insurer is also potentially in the gun if they facilitate that payment. We know, Christine, from some of the recent claims, insurers have actually been very, very helpful for clients in looking at where those funds are going to do the best to protect yourselves.
Absolutely, thank you. So we'll move on to the next topic, which is around the role of government. So in August this year, the Australian government released their 2020 cybersecurity strategy, where they committed $1.6 billion as investment over 10 years to create a more secure online world for Australians. And that includes working with industry to consider and clarify cybersecurity obligations. And some of this is going to be through that regulatory reform that, Alistair, you mentioned. So Alistair, could you share your thoughts on the 2020 cybersecurity strategy? And do you think it's going to bring about greater collaboration between government and corporations to tackle this ever-evolving cyber risk and resilience issue?
There's no doubt that there's more money in the 2020 strategy than there was in the 2016 strategy, for example, that I was responsible for implementing, at least in part. Most of that money, of course, is recycled through into the intelligence agencies themselves. So there's when people look at this, they can cut it lots of different ways. They can say, well, the money's staying with government, and therefore where's the help? We are having again tried, for many years to build better collaboration between industry and government. We all know it's an easier phrase to say than to do. I think government has made quite so I net out as being positive about the strategy. I should just say that there's a different lens taken to it. When Malcolm Turnbull launched the 2016 strategy, April of that year, it was more about opportunity as much as threat. If Australia developed a stronger, better cybersecurity industry, both in terms of technology and practitioners, then we would have better DNA to not just protect industry and government, but we'd have an industry that grows quickly and can compete with the world. I think a lot of that has been realised. There are some really interesting green shoots and good progress to be made there. This strategy focuses as much more on threat. There's no doubt you need, when you read the 2020 strategy, you've got to look at the critical infrastructure paper that I've already mentioned. They've got to be read together. And there you'll see the emphasis on this concept of critical infrastructure, different tiers of critical infrastructure, and the supply chain connected to that critical infrastructure. Now, from a cybersecurity perspective, that really includes everything, because you can't just draw a line and say, you on the other side of the line, we're going to leave vulnerable. You on this side of the line, we're going to protect. Because the vulnerabilities are imported through that connectivity and those processes. So it's an ambitious strategy, there's no doubt. And as I said, we're going to see much more muscular actions from government in terms of those regulatory and legal expectations and obligations upon companies and their boards. In terms of collaboration, threat feeds are interesting. So there's a lot of threat intelligence out there. I mean, I can buy commercial feeds. I can be part of essentially clubs that share threat feeds. What people need, what industry needs, is actionable intelligence, and it needs the right actionable intelligence at the time. So it's about the timeliness and the relevance, not the volume, because the volume of intelligence now is just extraordinary. I just need to know which threat is most relevant to me and what the sort of prophylactic action needs to be that my organisation takes. Now, we're not there yet, but I think we've come a long way. The government's investing in the joint cybersecurity centres, which is a good thing. You describe them as nascent now, very tough to do, but I see again green shoots there in terms of the real-time threat sharing. We're probably a ways off, but moving towards it. And I'd say that the goodwill is there still between industry and government, and certainly amongst industry as it realises it needs to do much more heavy lifting. I guess I'd conclude on saying that there is no cavalry coming to protect people. The government can't do this. The vast bulk of systems are quite rightly owned and operated by the private sector, and only they can really defend what they own. we can't expect government to step in, albeit they're going to try to legislate for some step-in powers. We need to be realistic to know that government will not come in to protect. And that therefore means organisations need to build up their own capabilities. They do need to share amongst themselves where it's lawful and proper to do so. Services firms will grow, such as ours, in response to that type of increasing need. And I think we'll net be better off. Having said that, the threat environment we're operating in is worse today than it was yesterday, and it'll be worse again tomorrow. And as a consequence, we may not be more secure or less risky or more resilient, but we're at least starting to bend the curve. We're probably just not bending that curve quite at the same pace that the risk curve is increasing.
Mm-hmm. And just on that point that you mentioned around the sharing of information, where it's lawful to do so, do you think that there's a reluctance at the moment by companies to actually provide, I guess, the lessons and learnings from cyber incidents that they've experienced amongst their peer group in the private sector for fear of, I guess, confidentiality issues, or that they may be used to leverage competitive advantages, for example?
So I'll start by saying I joined the Australian Federal Police in 1989. And if you go back and look at cases there where victims were blamed, in the offline world, women would be blamed for being in the wrong place at the wrong time. And courts and police learnt that you can't be saying that to a victim. No one asks to be victimised. And we started quite rightly shifting that offline victim language into talking more about why the offenders were wrong. We're not there yet when it comes to cyber security or cyber risk being realised. We often blame the victims, and we all know, and for those of us in this game, we know that sure, more can be done, but we haven't shifted the dialogue in this country to talking about blaming offenders, nation states, criminal groups and others who will do harm. Instead, we blame the victim organisations. So partly, yes, I think it's a fear of shaming. I don't see it as being a commercial interest one in the sense that I'm fearful someone else will use it. In my experience, those who are involved in the security and risk functions in organisations in Australia, public and private, are pretty good at cooperating with each other. I think it's more that fear of reputation, which is sad, because unless we talk about near misses or actual events involving confidentiality, integrity and availability, we won't learn as a society. I think we've matured a bit. I think the Notifiable data breach regime helped with that. It doesn't go far enough because it doesn't include near misses and it doesn't talk about integrity and availability. And it's probably the wrong entity. I like the OAIC, but it's not the only entity that should get this information. We need to get into a position as a society where we talk about these things more. I'm growing a moustache this month for Movember, so men talk about men's health, and by the way, I can shoot you all the link for donations. It's not my favourite thing to grow, but it's so we can have a conversation about testicular cancer, for example, which you guys aren't very good at talking about, or suicide. Same with cyber resilience and the problems that we're facing as organisations. We need to get smarter and better at having those conversations. So that's a long answer to your question to say I think it's misplaced fear. The best entity I've seen actually talk about a significant incident was the ANU, which was from pillar to post, kicked around. How did you allow a alleged nation state to be in you for the second time? They published a pretty good paper outlining what they saw, how they acted, and more about the offender. We need to have more of that. I don't know about what that then does in terms of potential class action and other such things. Shame on those class action people if they took advantage of it, but we need to get better at talking. Thank you.
Absolutely. And Lisa, Alistair mentioned the notifiable data breach statistics that are published regularly by the OAIC. What can organisations learn from that data that is published, and can it assist in developing effective cyber risk management strategies?
Yeah, there's a wealth of information that's provided in those regulator reports, and lessons learned are kind of everywhere to be seen, including in the AFR when they report on these incidents as well. So I think there's plenty of reference points to help inform what you do. What there isn't, and what some of my work involves is helping clients build that governance framework that suits them and really helps identify what the critical data assets are for them, what might need heightened security protections more than other sets of information. So actually really focusing in on the company itself, what its exposures are, what it needs in terms of having a license to operate, what it needs to run its business. It's not always going to be personal information or information that might be regulated by CPS 234 or something like that. It could be that there's critical information that the business needs to run, and so having your security strengthened in relation to those assets will be really important. Building in just a DNA of awareness across your organisation, particularly the IT function. And so, being aware of the click-through agreements that quite often, present themselves when you're building in technology into your business. They can often be negotiated, and they should be actually interrogated and not just kind of accepted, blindly. But that's about changing the sort of risk awareness within the culture as well. So I think the other thing that needs to be done at that business specific level is building in just basic deletion functionality for information. So functionality that can observe your data retention requirements and those sorts of things, but actually gets rid of that risk when it's no longer needed. The more information you hold, really, in today's environment, the greater the risk. So making sure that even just basic functionality like that, which is quite often overlooked, is built into your systems as well.
Mm-hmm. Great, thank you. So we'll move on to the final topic I wanted to cover today before we have some time for questions. So again, please utilise the Q&A function at the top of your screen if you'd like to send in some questions for our panel members. But the final topic is just around cyber insurance. And Craig, are you able to touch on cyber risk transfer solutions that are provided currently by the insurance market? And also maybe look at whether the market can play a greater role in assisting the improvement of risk management by possibly driving incentives for effective security controls to be put in place by insureds?
Sure, happy to give some comments here, Christine. So when cyber insurance was first becoming popular here in Australia, one of the key questions we got or was asked from clients and prospects was, yeah, but you haven't had any claims yet. How do we know that this policy is going to work? I'm really pleased to be able to say we're now over that threshold. Perhaps insurers may not be quite as positive as I am, but what we now know with certainty is that these policies work. Christine mentioned or referred to ransomware claims recently, and then we've spoken about the subsequent ransom payment issues. Those have been the most recent sorts of claims, but we've had other more traditional claims, and some of those have been first party, some of those have been third party. What we now know is that these cyber policies not only have just worked, but they've actually worked really well. And we can say, give confidence to buyers of cyber insurance that the reasons that you buy the cover are valid, and that the service delivery is A1. Now, a lot of people buy cyber insurance not just for the immediate level of protection, data breach and mandatory notification things, etc., but for the support services that might come with that product. And so I'm talking about things like access to a lawyer, access to public relations firms, access to managing the issue itself, those forensic accounting, that sort of stuff. Those services have worked really, really well. And so we can give much greater certainty to clients around that. But what that then goes on to, which is the sort of the second part of Christine's comment, is around when you have those issues, you then go on to learn from those. And insurers, via a bit of if you like, a consulting function, in conjunction with ourselves, focus a little bit around identifying what the risk issues are and then quantifying what those are, or, as I said, often in some live examples. And then importantly, a consideration for insurers will be about which support services or entities you might be using in order to help you through a particular scenario. And so there are many firms that are emerging in this space, and there are lots and lots of assistance available. Look carefully about who you're using. You choose the right ones, and they will be able to help you not only manage a claim scenario, but also manage pre-loss, right? So looking at your organisation and make sure that you're appropriately prepared, dealing with some of the things that both Alistair and Lisa have spoken about. So I guess you would expect me to say this as an insurance broker, but seriously, we are looking at helping clients manage the risk much before we look at transferring the risk. But when you do get to that stage, the transference, we can now say to you that there are positive solutions here for you, and it should just now become part of an appropriate risk management framework. But the last comment that I'd like to make is that cyber policies are not like buying a car insurance policy, right? They vary dramatically. This is an area of, if you like, uber sensitivity, and products are changing and evolving very, very rapidly. And so when you come to look at purchasing or putting in place cyber insurance, what we've been able to do is create specifically tailored solutions. Right? You don't have to take a product that's off the shelf. Very often those won't work for you in an optimum situation. So be working in conjunction with your broker and making sure that the product that you put in place is appropriately tailored for your needs and achieves the goals and objectives that you set for yourself. Christine and her colleagues will be only too happy to.
Absolutely. Thank you, Craig. So that concludes the formal part of our session, and we'll just move to a quick Q&A section. So I'll kick off with a question just around, it is around cybersecurity and I guess how it's mapped within an organization, because often cybersecurity risk is sort of mapped outside of enterprise risk. And I think that contributes to quite a challenge of creating that enterprise-wide awareness of cybersecurity and cyber risk resilience. So maybe Lisa, if I could start with you, do corporate structures need to change so that potentially cybersecurity sits alongside the CIO and the chief risk officer so that it becomes enmeshed in the overall enterprise risk management planning and strategies? Or is there maybe another solution that we can maybe think about that would help create that enterprise-wide awareness and culture?
Sure, thank you.
Yeah, thank you. I think it starts with
you, Lisa. You go. Sorry, Lisa. I
sorry.
I heard Alistair, but I'm getting old. Go, Lisa.
Oh, just quickly, I think it obviously starts at director level, at board level. It is, as we've discussed today, a board level responsibility. And then, getting people within your organisation to support you as a director is critical. But it really does require clearly assigning roles and responsibilities throughout the organisation in relation to this risk. There's an education piece enterprise-wide that comes with that. So, to take the example of data breaches, well, you can't detect a data breach if you don't know what it is. And it's not, just a digital proposition. There's physical information assets as well still. And those risks can apply across the board. So making sure all of your employees know what a disclosure is, sending an email outside of your organisation to someone who it's not intended to go to is a disclosure. And so just, those basic, I think, as Alistair said before, there's a new language that everybody needs to learn in order to perform their roles. And so I think it starts, absolutely at the top, but it's something that needs to be applied across the organisation. And we're seeing a lot of data governance frameworks being built that will allocate data stewards or, data ambassadors or something throughout the organisation from top to bottom, front of house, back of house, everywhere, so that they're the people who are really in the know. They're accessible to everyone within the organisation to just discuss the issue. And that way, I think you're building an environment that will help directors discharge their duties and to protect, the company assets and let it get on with what it's doing without the distractions of data breaches and, class actions and all of those things.
Alistair, did you want to add?
Yeah, so I have a view that for too long, CISOs, Chief Information Security Officers, have sat inside the technical part of organisations, so they largely sit under the CIO, and I think that's problematic. I quite like what some of the banks have been doing lately, where one, they don't really draw a distinction between the information security officer bit and the security officer bit. So we're increasingly seeing chief security officers who are at the right level inside an organisation, perhaps sitting beside the chief risk officer, because we know security and risk are different. Even though I've said we should be using the phrase, cyber risk resilience, really. I don't always win friends, oddly, as I go around the place saying this, but I like to see CISOs out from underneath the CIO, because it's not a technical problem. Cybersecurity, cyber risk is not a technical problem. It's a people problem that's facilitated by technology. Offenders, whether they're nation states or criminals, target end users. It's a people thing, just facilitated by technology. So I'd like to see increasingly in organisations a chief security officer who reports to, maybe it's the head of risk, but preferably, in my view, to the CEO, because of that increased level of exposure to the board. In the organisation where the daily work is done, you need to see these people elevated, powerful enough to be able to move things inside organisations. And then I'd also add that we know that physical compromise can lead to electronic compromise, and therefore this concept of combining physical risk with this IT risk is I think the best practice model. NBN do it, several of the banks now do it, and I think that's where we'll see the market heading in terms of those specialised people inside the organisation who can bring that muscular approach up to the board on what needs to be done.
Great, thank you. And just a comment that's come through from the audience. So Alistair, you're absolutely right. Cyber risk is a people problem. Cyber sitting in the technical function does hinder progress and autonomy to audit the systems and practices independently. So I think it's a really important point that you've just made, Lisa and Alistair. Thank you. And just a final question for you, Craig. So I would be remiss in not utilising your absolute Dino expertise while I've got you on this panel and call. Now we saw, not necessarily related to cyber risk and cybersecurity, but we saw last week the Worley-Parsons decision, the class action that went to full trial, and then obviously Maya happened last year. Do you think that poses potentially a positive outlook for class actions in general, that now we've had 2 of them go to trial, and in both instances they have seemed to be more in favour of the defendant than the class action shareholders and plaintiffs?
It certainly is the commentary that I want to be putting out there, Christine, because it's something that I've spoken to well before these 2 judgments. And I use an analogy when I'm talking to boards, which is the bully in the playground. And so if someone is kicking sand in your face, at some point, they're going to keep doing it until you stand up and say, hang on, stop doing it. Yeah. If you genuinely believe that you haven't done the wrong thing, or you've got a defendable position, then defend yourself. Right now, it's very easy for me to say that. And if you're the CEO or the CFO of a large listed company, you don't want to go to the board and say, well, I'm putting you at risk of potentially, $100, $200, $500 million loss, right? When we could have settled it for a much smaller number, right? But by settling, which is how all of them have been up until these two recent decisions, in my mind, it simply fuels the system. What I do say, particularly in the Worley case, I mean, the Meyer decision, I'm not quite sure anyone really knows who won, or did anyone even win, or what the judgment actually meant. But in the Worley case, we have a very clear outcome. And I think it should be used as an example to companies and boards who are making these decisions to say, you know what, hang on, maybe we should look closely or revisit those decisions around potentially settling. Yeah, we should run these cases. And my final comment is a lot of people make the assumption that it's actually the insurers that are forcing the companies to settle these shareholder class actions. In my experience, it's actually the opposite of that. Insurers would actually like to go on and defend more of them, but it tends to be more of the board decision that says, you know, actually, no, we don't want to take that risk. We want to get in and get out. So, but also bear in mind, this is two determinations, all right? There are many others, right? As I understand, Worley could potentially be appealed. But at least it is some change in the landscape. And so I'm trying to say, hey, use it as an example. You don't have to just roll over. There are other options.
Absolutely. Thanks, Craig. So that concludes the second masterclass in our cyber risk series. And I'm sure everyone would agree that our panel members have today provided absolutely valuable and critical insight into matters that impact all boards and, you know, even management. So thank you so much, Lisa, Craig and Alistair, for your valuable time and expertise today in participating in our panel. Really appreciate it. So we still have a fantastic lineup of masterclass sessions over the next 2 weeks, and registrations are still open. Our next session will be on Tuesday, the 24th of November at 12 p.m. Australian Eastern Daylight Time, where John O'Su, the head of our cyber division in New Zealand, and Faisal Janif, our head of cyber consulting in the Pacific, are going to be presenting a deep dive into the management of critical supply chains. And of course, if there are any follow-up questions or you'd like to discuss cyber risk further, please reach out to your Marsh client advocate or a member of the Marsh Pacific team. A cyber team would be more than happy to assist. So thank you everyone for your attendance today and have a wonderful day.